Thank you, Dr. Ho. Thank you, Dean Liu, for the invitation to this prestigious university. I'm very happy to be here to talk about United States patent law and specifically damages. There are three aspects of patent litigation in the United States that, if not unique to the United States, are certainly unusual when compared to the rest of the world. One of them is discovery and the amount of discovery that takes place in the United States. I am thankfully not going to talk about that today. It's caused enough headaches around the world. I don't need to touch on that. But the other two, I think, are very important when talking about damages. First is the size of the damages awards in the United States tend to be much larger than anywhere else in the world. And I hope today to give you a taste and understanding for why that might be, because I'm actually going to take you through a real case. I'm going to use the plaintiff's slides that were presented to the jury, which is the third thing about United States patent litigation that's very different than the rest of the world, is that these decisions, the amount of the damages, whether something infringes, whether the patent's valid, these are decisions that the United States generally trusts to the jury. And the jury isn't specially educated. Often they don't have university degrees, sometimes not even high school degrees. And we're asking them to make these very complex calculations. And I'm going to show you how we do that in the United States through a presentation that was actually presented at a trial in San Francisco not too long ago. So let me start with just setting out the basic parameters for damages in the United States. There are two types of damages that you can generally recover in the United States. The first is lost profits. How much money did the patent owner lose as a result of the infringement from its competitor? And the second, which is much more common, is the reasonable royalty damage. And the reasonable royalty is the minimum amount that a patentee can recover. So often in cases... there you go. Okay, often in cases where the patent owner can recover either lost profits or reasonable royalty, they'll try to go for lost profits because, as I'll show you, the damages for a lost profits calculation can get very large very quickly. Okay, there are three parts to a lost profits analysis. The first is the kind of lost profit that most of us think about when we think about lost profits, and that is the revenue and the profits that the patent owner lost as a result of the infringement. The sales that the defendant made should have been made by the patent owner in the first place. The second kind of damage that is suffered in a lost profits analysis is what we call price erosion. And that is the effect of the infringer in the marketplace not only takes sales away from the patent owner, it forces the patent owner to lower its prices. And so the courts try and allow the patent owner to recover the losses it suffered as a result of having to lower its prices to meet the competition that the infringers brought on. And then the final category is increased expenditure. Maybe because of the competition from the infringer, the patent owner needs to advertise more. Well, there are costs associated with advertising. Maybe they need to hire more salespeople to get out there and try and convince the customers to stay with. Maybe those salespeople have to travel more, to have face-to-face meetings with customers in order to try and convince the customer to not abandon the patent owner for the infringer. So all of these are real costs that patent owners suffer when there's infringement, and the courts try to be fair to the patent owner and let them try to recover these. The biggest barrier to getting lost profits damages is this element of proof. You have to prove, if you're the patent owner, that the sales the infringer made would have been yours if the infringer hadn't put an infringing product on the marketplace. And this has to be shown by real evidence in the real world. It can't be done by speculation or guesswork. And that's why lost profits are often very difficult for patent owners to recover. But when they do try and recover, they typically use this analysis. And this is called the Panduit analysis, based on a case from the 1970s or 1980s, I believe. 1982, if I remember correctly. And it has a 4-part test. The first part is demand for the patented product. As I'm going to show you, this is almost never really contested in district court litigation, because the fact of the matter is, if you're fighting over the product in litigation, it's because there's demand for it out there in the marketplace. The infringer has been successful selling its product, that's why you're suing them. So the first element is almost always met and almost never contested. The second one is where the biggest fight is. Whether there are non-infringing alternatives that are out there. So even if the infringer sold an infringing product, if the infringer could have sold something else out there in the marketplace and still taken your sales away from you, you're not entitled to lost profits. This is probably the most hard-fought area in patent litigation when lost profits are involved. The third part sometimes comes into play, and that is, in the world you need to create where there is no infringer, and the customers no longer would go to the infringer, they'd come to the patent owner in order to buy the product, the patent owner needs to show that they could have made those sales, that they had the manufacturing capability to meet the increased demand, that they had the sales force in place, that they had the marketing expertise in place. This is sometimes a problem for smaller companies that may have difficulty scaling up in order to meet the demand that would have been there if the defendant hadn't been infringing. And then finally is the amount of profit that would have been made. How much profit was actually lost as a result of the infringement? Now, a reasonable royalty is less rigorous. It's less defined, and it's more flexible. We talked, Dean Liu referenced this earlier. It's a very flexible analysis and often difficult to nail down and get parties to agree on how it would look. But what you need to try and do in a reasonable royalty analysis is create another fictional world where instead of just releasing its product in competition with the infringer, the accused infringer sat down on the day before the first sale was going to take place, just before infringement occurred. And what would happen if the patent owner and the accused infringer sat down at a table and negotiated an arm's-length contract for the license back before the infringement began? It requires a lot of imagination, and there are a lot of different ways that you can approach the analysis, and I'm going to be discussing some of them later today. The framework that most people use in the United States in litigation is what we call the Georgia-Pacific framework, and this is again named after a very old case, almost 50 years old now, out of New York City. And in this case, the district court judge tried to articulate what factors are taken into account in this fictional negotiation between the infringer and the patent owner just before the infringement began. And so the court listed the things that usually would be considered in this kind of analysis. The first and most important, I think everyone agrees, is there an existing license already in place between the patent owner and someone else for the patent? Often you don't have this in litigation. So the first factor, although if it's there, it's considered the most important factor in the analysis, usually isn't there. The second is, what about industry custom? If you're talking about infringement of flash memory chips, well, there's a lot of licensing activity in the flash memory field. So the experts will go through licenses that were struck by SanDisk or Toshiba in that area and try to compare those licenses to the situation we have here, the patents involved in those licenses to the patent involved in the litigation. The parties' licensing policies are also very important. Does the patent owner have a habit of licensing its technology very freely? Or is it the kind of company that guards its intellectual property very closely and almost never licenses its technology? What about the relationship between the parties? A patent owner is going to charge a competitor a lot more money for a license because that competitor is going to take customers away from the patent owner, and the patent owner knows it. So the license fee is going to be higher between competitors than it would be between a patent owner and someone who wants to license the patent in an unrelated area where it's not going to affect the customer base of the patent owner. How much money does the infringer anticipate making with the accused product? And we see in litigation, because we have discovery, we get to see the marketing department's analysis of how important this product should be to the bottom line of the company, how profitable it should be. This is a factor that you take into account. If the marketing department of the accused infringer is telling the CEO, we're going to make a lot of money off this product because of the infringing feature, that company is going to pay a lot more money for a license than an infringer who would say, well, some customers like it, will get some marginal increase in sales, but not significant. That makes a big difference in the analysis. The comparative utility of the infringing technology compared to other technologies, especially non-infringing alternatives. It makes common sense that if a patent owner is going to sit down with an infringer and start driving a very hard bargain, start asking for a lot of money, the infringer is going to say, I don't really need your technology. I can go and I can license a patent from somebody else, or I can develop my own technology in-house very cheaply. It may not be quite as good as the infringing technology, but it's worth it considering how much money you're trying to charge me. So if there are alternatives, that'll drive down the price of the license. And then finally, we talk about collateral benefits and convoyed sales. The razor and the razor blade analogy that every economist likes to use. If I'm going to sell razors, I've guaranteed that I've got customers now who are going to come back to me and buy razor blades as the razor blades wear away. So I not only have the initial sale I'm going to get all those future sales as well. If you have that situation, an infringer will pay more for a license that promises future returns in addition to the initial infringing sale. And then finally, the relationship between the feature claimed in the patent and the product that's going to be sold by the infringer. Is this a core feature? Is this a really important feature of the product, or is it an option that only some customers like? That makes a big difference in the analysis. The state of development of the patented invention, is it still just a paper patent? It hasn't been proven to work yet in an actual product? Or is it a product that the patent owner has been selling for years very successfully? That also has an effect on the price. And then finally, the number of years left on the patent. Okay, I'm going to take you now through a case study of lost profits in a case that was actually litigated in the Northern District of California in San Francisco not too long ago between an American company called Nuance. You might know Nuance from its Dragon software, or it was one of the creators of Siri that's used on the Apple iPhone, and a Russian startup company, smaller, it was small at the time, now it's very big, Abby Software, which is a Russian company that began competing with Nuance in the area of the technology involved in the early 2000s, late 1990s. Nuance sued Abby for patent infringement and for trade dress infringement. I'll show you the boxes shortly, but Nuance said that the software box that Abby was using to sell its software looked too much like Nuance's software. And so there was a patent infringement aspect to the case and a trade dress infringement aspect to the case. Here are the products involved. Nuance's package on the left came out first, and shortly afterwards, Abby released its package. Nuance got very angry, not only because it thought Abby was infringing its patents, but also because it thought it copied the boxes that Nuance was using. So it sued it in court in San Francisco. The technology involved was optical character recognition, and I promise you this is not a technology presentation. I'll make this quick and painless. But you need to understand what optical character recognition is in order to understand the damages that Nuance claimed to suffer. Optical character recognition comes into play when you have an old document and say you want to take this contract and revise it for another deal that you're making. You may want to change the names of the parties, you want to change the dates, you may want to change something in the contract. You have a choice. What you might do is you might just hand this to your colleague or do it yourself and type the contract in yourself into a computer, into a word processing program. That takes a lot of time. It introduces the possibility of a lot of errors. And you might want to look for a way to automate that process. Well, optical character recognition allows you to automate that process. And what you do is you put the document on a scanner. The scanner literally takes a picture of the document and then transfers it into the computer. And the computer converts that image of the document using the OCR process into a computer file that you can now use. And you can take the computer file, you can search for words on that computer file, you can edit the computer file, or you can reformat it as you want. You have converted a physical document into an electronic document that you can now do all kinds of things with. This is very powerful technology, and consumers like it very much. So, Nuance sues Abbey and its larger customer, Lexmark. Lexmark used to be Nuance's largest customer until Abbey came on the scene and convinced Lexmark to use Abbey software instead of Nuance's software. And out of frustration, Nuance sued not only Abbey but also Lexmark as kind of a signal to the rest of its customers, this is what's going to happen if you don't stay with us and if you go and use Abbey instead of our software. This is the actual analysis. So I am going to pretend to be Dr. Putnam, who is an actual expert. He is a very frequent expert, mostly for patentees in the United States. So some of you may have worked on cases where Dr. Putnam has been involved. He has a very good resume. A PhD from Yale University, one of the greatest universities in the United States. And he has a number of publications. He's a very impressive person when he gets up on the stand and tells the jury how much the damages should be. So now I'm going to pretend to be Dr. Putnam. The goal here with this analysis is to try and put Nuance back in the place it would have been if it didn't face this unfair competition from Abbey. So before Abbey came on the scene, Nuance had a very successful business. It was selling the patented technology. The customers were very loyal. They paid money to Nuance for the technology. It was very valuable. And then Abbey and Lexmark came along. And those customers went away from Nuance and went to Abbey and Lexmark. You're going to hear other experts and other witnesses tell you that they got that money as a result of infringement. I'm not going to talk about infringement. I'm not a technical expert. I can't tell you whether they infringe or not. But if you decide that Abbey and Lexmark infringe, it's my job to tell you how to make Nuance whole again. How much of the money that Abbey and Lexmark made as a result of the infringement should go back to Nuance in order to make Nuance whole and put it in the place it would have been if there was no infringement. I'm going to show you three aspects for patent damages: lost profits, price erosion, and a reasonable royalty. So let's start with the number of infringing sales that Abbey made just in the United States. We're only talking about the United States here because it's only a United States patent. Abbey and Lexmark, between them, sold over 17.5 million infringing units in what we call the OEM space, original equipment manufacturers. These are printer manufacturers who want to provide OCR functionality to their customers, so that if you buy a multifunction printer, a printer that scans, prints, and faxes, customers find that OCR software is very valuable in that context. And not only Lexmark's customers, but Epson, Panasonic, Fujitsu as well. All of them bought infringing software from Abbey to provide to their customers, 17.5 million copies of the software, in fact. So how does this channel work? How are the sales actually made? Well, Nuance provides a copy of its software on a disk to Lexmark. Lexmark then takes that disk and puts it in the box with the printers that are going to be sold at retail, so that when the customer sees the Lexmark printer on the shelf at the store, they see not only that it can scan and print and fax, but they also see that there's Nuance OCR software inside the box, so they don't have to go out and buy a separate copy of the software. They can get it all in one box. Well, Nuance had a very successful business with Lexmark when it did that. And then in the early 2000s, Abby came along and started telling Lexmark that it had a choice, that it could use Abby's infringing software instead of Nuance's software. And that made Lexmark reconsider its contract with Nuance. Now, what Nuance considered very important was the quality of the software. Its customers wanted the highest quality OCR software there is. And you're going to hear other experts talk about the quality of Abby's software and the quality of Nuance's software. Even though they'll say Nuance's software is a little better than Abby's, there's no question that Abby's and Nuance's software is so much better than anything else on the market that if you want high-quality OCR, if you want the best quality for your customers, there are only two choices.